The goal with this video is to introduce you to one of the important standards underlying patents, which is novelty. Before we get to some of the specifics, though, I just want to make sure we're all on the same page. So, for an invention to be patentable, it has to fulfill three prerequisites. It must be novel, it has to be a non-obvious improvement over what has already been done, and it has to be the kind of creation that a patent is intended to cover. We often think of patent standards in preliminary terms. That is, what do I have to show or prove to get a patent in the first place? Obviously, this is of great importance to inventors who are seeking protection for their innovations. But I just want to point out here that the standards remain important even after one has successfully persuaded the PTO to grant the patent. For instance, consider a situation where you have a patent and then discover that a competitor is infringing the claims. Of course, you try to negotiate, but let's say the discussions fail, so you are forced to sue. The competitor might then simply give in, but more likely the lawyers will argue that the company is not violating your patent. They might say, for instance, that their product doesn't use the attributes covered by the patent claims. Or, in simple terms, we're not doing what your patent covers. Beyond that, though, they may say, well, even if we violate the claims in your patent should never have been granted in the first place, and so it's invalid, which means you can't stop us. To this end, they may argue that the PTO examiner was just wrong. Or they may find something that she overlooked, which demonstrates that your invention was not novel to begin with, or makes it appear as obvious. Thus, for all kinds of reasons, it's important to treat these standards as a lifelong affair. So, let's start specifically with the novelty standard, and then we'll go over non-obviousness next. As I mentioned in the general introduction to patents, the American Invents Act made a significant change to the novelty standard by making the application date the focal point rather than the invention date. Thus, now, when two or more inventors are working on the same invention, then the first of them to file the patent application at the PTO is entitled to get the patent. And trust me, this is not simply an abstract situation, because there are often social problems or needs that multiple people try to solve at the same time. Just consider all the firms that invested in developing COVID-19 vaccines once the virus began to spread. Anyway, under the new law, the first to file gets it. Prior to the revision, which took place in 2013, the patent would go to the person who could prove that he made the invention first. This created all kinds of difficulties and weirdness with determining who should own the patent because it's hard to pin down the specific date that someone actually makes an invention. Fortunately, we don't need to get bogged down with this anymore. But understand that there is an invention process that begins with a detailed conception of its design and ends with a prototype where the idea is reduced to practice. So, if you are comparing who invented first, which date should count? Under the old law, the conception date ruled, as long as you thereafter diligently reduced the idea to practice. So, what is the conception date? Don't ask. What kinds of efforts are diligent? Again, I'd say, don't ask. How do you prove all these things? Well, lab notebooks help, but without good ones, I don't know. I guess don't ask. You can see what a mess this could turn out to be. Well, now all this craziness about who invented first no longer arises. Instead, we just need to figure out who filed the application first. And that's pretty much a no-brainer. Figure 1 demonstrates, with its admittedly lame graphics, how much simpler the situation is now. Look at the timelines for the two inventors, A and B, who have been working on developing an invention at around the same time. To start, think how the process for determining who gets the patent might go with the old first-to-invent standard. B filed first. And so, up front, the application provides enough information for a skilled individual to make the invention. Therefore, it can serve as evidence that B has successfully reduced the invention to practice. But then A will say, wait, I can prove that I had a working prototype before that date, so I have priority. Then B may come back and indicate that he has lab notebooks demonstrating that he reduced the invention to practice earlier. And indeed, conceived of the invention before that. There we go. And then A may say, but wait, I have lab books and they demonstrate I conceived of the invention before you thought of it. And yes, it took me a while to take the next steps, but I still proceeded in a diligent fashion. A diligent amount of time, he says. And then B, of course, might retort, you weren't diligent at all, so your conception date doesn't count, and so on. Well, yikes! You can see that this can get pretty messy. Under the new law, a lot of this complexity is eliminated, because much of it is just no longer relevant. The general rule is that the first inventor to file the application is entitled to the patent. And so assuming that B is actually an inventor, he wins. End of story. So you can see the appeal of the first-to-file priority system. I have to tell you, though, that many small inventors nonetheless preferred the previous method based on the invention date. They believe the new approach provides additional advantages to big corporations with sophisticated legal staffs that have the machinery to aggressively file patent applications as soon as possible. Sometimes the individual who tinkers in the garage takes much longer to gather the information, resources, and wherewithal to file a patent application, which may keep her from controlling an invention that she rightfully should own by virtue of being the first to create it. On the other hand, there is substantial appeal to the utter simplicity of the revised approach. And to be frank, the results are almost always the same anyway. A question I often get asked is, well, since the first to file gets priority, what happens if someone likes break into my facilities, sees what I'm doing, basically steals it, and then immediately files a patent application before I am ready to do it? Do they get the patent? Or what if I have an employee who's learned everything I've been working on, and then that person leaves the company and starts their own firm, and files a patent application before I do for an invention that I had been finalizing? He's first to file, but really, is that fair? So I tried to pencil this out in figure 2 here, which shows that B filed the application first, but B learned the information about the invention from A, which is what I put this dotted arrow here for. So what's going to happen here is that when the examiner reviews A's application, he's going to notify A that B has priority because B filed first. A is going to think, wait a minute, B didn't come up with that. He got it from me. And so he's not an inventor. And since he's not an inventor, he's not the first inventor to file. Rather, I am. Well, the law provides A with an opportunity to demonstrate this in a kind of administrative trial at the Patent and Trademark Office called a derivation proceeding. And if A proves at the proceeding that B derived his knowledge about the invention from A, then the PTO will grant the patent to A, even though B filed first. Okay. This means that first to file isn't always all that simple, because there is this nuance about potential derivation. And so it is conceivable that there will be a battle about whether the first filer learned about the invention from the second filer. For this reason, it may still be advisable to keep good records of the entire invention process. If you are the first to file, the records may help document that you methodically invented on your own. And if you are second, they may indicate the contacts you had with the individual who filed first. For this reason, although keeping records of the invention process is no longer nearly as important as it used to be, many technology firms still ask inventors working in their labs to maintain invention notebooks. Indeed, it would not surprise me if some of you working in these environments have been instructed to do so. So for completeness, I have added one more item to this slide that addresses a topic we will cover when we review procedures for getting patents in the international realm. The bottom line is that there may be individuals from other countries who file their US patent applications after you do. But due to the operation of international treaties, their filing dates in their home countries may be the ones that count. And so if that date precedes the day that you filed in the US, they ultimately may have priority over you to get the US patent. Again, you can mentally put this aside for now, and we will return to it a little bit later. Okay. The other component of the novelty standard establishes that an inventor cannot control an innovation via a patent if others have already publicly disclosed information about the invention prior to the application filing date. As mentioned, this was a major change from the previous law that based novelty on the invention date. You should also recognize that the public disclosure can arise in many different ways. The invention can be described in a magazine article. It might be shown at a trade show. It might be sold. Just about anything that puts it in front of other eyeballs, and anywhere in the world. So take a look at Figure 3 that depicts the development of an invention and the filing of a patent application. Under the current law, which bars any public disclosure prior to the filing date, the answer to the question about whether the invention is patentable is easy. It's no. With the prior law, we would have to look further and determine things like the dates of conception and reduction to practice, which complicates the evaluation. But the answer to the question of whether you get the patent might actually be yes. Also, recognize that under current practice, there is typically greater urgency to file the application as soon as you can, because every day you delay increases the chance that someone else might make a public disclosure that bars your ability to get a patent. Under the old law, you could relax a little more, knowing that you still retain rights to obtain the patent as long as you could demonstrate that you invented before the disclosure. Another point I'd like to mention here is how the novelty standard threatens a patent throughout its life. So we will look at the patent process later and the role that a patent search plays in it. But when you apply for a patent, the Patent Office will look for and review information about public disclosures of similar inventions to determine if your invention was novel when you applied. The examiner will do the best job possible, but she only has a limited amount of time and resources to spend on your application. So she may miss things that could have been relevant, and without seeing them, could decide to grant the patent. This is why I previously warned you about patent risks, even after you obtain a patent. Because now, if you sue a company for allegedly infringing your patent, they have tremendous incentive to focus substantial time and money to look for any information, even an obscure published article or a failed product launch that predated your application date. And if they find it, then a judge may rule that your patent was mistakenly granted, and so cancel it. So I want you to think about this a little and consider whether you might even want to help the examiner find all the relevant information at the very beginning to ward off problems later on. You may end up reducing the breadth of your patent rights by doing this, but you also may rest easier over the long term. All right. The issue is whether an invention has been publicly disclosed by someone else prior to the patent application date. The notion of public disclosure may be broader than you initially thought, and the case of Dunlop versus Ram makes this pretty clear. The case is relatively old and was decided when patent law was governed by the first-to-invent standard. Thus, the relevant disclosure must be prior to the invention date. However, its guiding principles about public disclosure still hold true today. Here are the facts. In February 1965, Dunlop invented a golf ball cover using a substance called surlyn that made it very tough to cut. The company persuaded the PTO examiner that the use of surlyn for golf balls was novel and non-obvious, and the PTO granted a patent for the invention. After receiving the patent, Dunlop learned that another company, Ram, was selling a ball made of surlyn in violation of its patent, and so Dunlop sued Ram for patent infringement. So I actually have some golf balls that I found on eBay, Golden Ram. So this is the company. Frankly, I don't play much golf, and I don't know if they exist anymore. I don't think so, but this is the company, and so this is what we're talking about. Ram making these golf balls. And so Ram is sued, and so this is a big deal to Ram. So it dug around, and it learned about an individual named Wagner who had once tinkered with creating golf balls. Curiously, Wagner determined that surlyn made them really tough. So he produced some balls and handed them out at a club for members to try. And the response was so good that he then received orders for over 12,000 golf balls, all slightly before February 1965. Thus, the balls definitely were publicly sold and distributed prior to Dunlop's date of invention. What made this case somewhat difficult is that Wagner never told anyone about the ingredient that made his balls so tough. In fact, he put the formula in a vault and instructed his daughter not to tell anyone how they were made if anything ever happened to him. So the balls were publicly sold, but nobody knew at the time about the underlying invention that made them perform so well. The question is, given these circumstances, has there been public disclosure of the invention? According to the court, the answer is yes. The invention was in the hands of the public, so experts in the field could tear it apart and learn how it works, despite the initial secrecy regarding the use of Serlin. The court look at that. The court called this a non-informing public use because the balls were in public use, although the invention was not readily apparent. In other words, if the invention is played in public hands, it counts, even if it is not immediately clear how the invention works. In its ruling, the court distinguished Wagner's behavior from what it called a secret use, which would not be treated as a public disclosure. An example of this would be a secret process that I use within my own facilities to manufacture products that I then sell. Although the public could then tear the products apart and study them, that would not be enough to figure out the process used to make them. So the process remains a secret despite the sale of the products made with that process. For this reason, the law does not treat the process as being publicly disclosed. And this means that if someone later invents the same process and then files for a patent, this person might actually be able to get it because the process had not yet been publicly used or disclosed. So I want you to think about this a little more. Now, you may have a situation where you invent a manufacturing process and someone later invents the same thing. That other person might be able to get a valid patent on it because you kept it as a trade secret within the confines of your facilities. Now, let's assume that this other person, who now has a patent, discovers that you are using the process in your factory and so sues you for infringement. Can you believe it? You invented the process first, and now this other guy is suing you for violating his patent. Are you kidding me? Can this really happen? And the answer is, yeah, you bet. However, it obviously can seem a little bit unfair. To remedy the situation, the patent law provides for what are called prior user rights. And the American Invents Act expanded their application. So before the AIA, prior user rights were available only for business methods, but now they apply to most commercial processes. So the deal is that if you make a secret use of an invention within your facilities, another company can still get the patent. But based on your prior user rights, you may have the ability to continue using the process without having to pay anything to the patent owner. And I'm going to emphasize the word may, because there are lots of exceptions and limitations that we're just not going to get into here. Now, I want to move on to another important topic regarding public disclosure, which has to do with the mysteriously named one-year grace period. And notice that I put the word grace in quotes. Take a look at Figure 4, while I go over this. Here's the deal. Typically, one can't get a patent if there's been a public disclosure prior to filing. Thus, if others disclose the invention before you file, you are typically cooked. Similarly, if you disclose, others then cannot get a valid patent. That's what Figure 4 depicts when A discloses before B files. There. But let's say you show your product at a trade show or test market some items to see whether there actually might be a market for the invention. And you do this before even thinking about patents. Will your own public disclosure bar you from getting a patent since it took place before you filed? And the answer in the United States is that you can still get a valid patent as long as you file the patent application within 1 year of your patent disclosure. That's what this part is showing. It's called a grace period because by the grace of the law, you are given a year to file after your disclosure, something others would not receive. So, lucky you, you are graced with 1 year to file. But I've encountered many inventors who might think of it in other terms. Take a Cal Poly industrial technology team that once sold this really cool wine bottle holder. It had a design that made it look like a person was lying back and drinking the wine. It sold out in like 3 seconds, really. So this was like in June. So in September of the following year, some of the team members visited my office, and they said they now wanted to move forward with the business. And were thinking about maybe a patent and wondering if it were worth it, et cetera, et cetera. So I actually remembered the item because I actually bought one and said, hey, didn't you sell those out on Dexter Lawn around 15 months ago? And they said, yeah. And of course, then I had to tell them the bad news, that they had lost the opportunity for a valid patent because they waited too long after their public sales. And I can tell you that they weren't thinking at that point of that 1 year limit as some form of grace period. I'd say given their expressions, it would be more on the lines of, I'd say like a screw period. So that's why I put grace in quotes and emphasize that this can be a trap for the unwary. Because if you don't know the law, it can unexpectedly serve to bite you. On the other hand, when we soon expand our horizons to the international arena, we will see that the 1 year period does amount to some significant grace compared to other countries, because their grace periods are often shorter. For instance, in some Asian countries, the grace period may be 6 months, and in Europe, there typically is no grace period at all. So in that light, 1 year may seem rather generous and liberal. Also, keep this in mind when we consider strategies for obtaining patents overseas. Because if you sell or demonstrate your product before filing, you may be okay in the United States, but destroy opportunities for protection in other important regions. Now, I want you to look again at Figure 4 and notice that B's invention date is before A. Okay, we know that the invention dates are no longer relevant. Still, I want you to see that B invented first, but waited to get his act together. In the meantime, before he filed his application, A made some public disclosure, such as through sales, a news article, or a demonstration. This means that B can no longer get a valid patent. A, though, can still get a patent as long as she files within 1 year of her disclosing event. That's what this is about. Oh, of course, if it takes her over a year, then neither of them can get a valid patent. Okay, I get asked this question a lot. What if I make a public disclosure before I file, knowing that I have a 1 year grace period, and then some other person makes their own disclosure before I file my patent application? I tried to depict this in Figure 5, where I am A and the subsequent disclosure is B. Does B's disclosure prevent A from having a valid patent because he publicly disclosed before A filed? And the answer is no. A is still okay. Once A discloses, he retains his 1 year grace period even if others disclose in the interim before he files. That's why I marked B's disclosure with an X here in Figure 5, indicating that it does not serve to invalidate A's patent. Now, let's drill down on this a little bit more. You have just solved a problem, but realize that others have been working on the same thing. You also know that the first to file will have priority, but you need time to work with an attorney and draft the application. One strategy that some lawyers suggest is simply publishing information about the invention immediately, which will prevent anyone else from getting a patent because you disclosed before they could file. However, you would then have a year under the grace period to get your application filed and secure the US patent. Well, that's all fine, but here's the rub. By publishing before you file, you may jeopardize your ability to obtain patents in countries that have shorter or no grace periods. Remember, in Europe, for instance, you typically can't make a public disclosure before you file. So you really have to be mindful of your international patent intentions before you implement this filing strategy. Okay, that wraps up all I want to say here about novelty. The next standard we need to address is non-obviousness, so stay tuned.